This is a current trends case brief. The case citation is Bedihi v. Canada, Citizenship and Immigration, 2017, FC 64. Ms. Bedihi, her husband, and their son are nationals of Iran who arrived in Canada in 2013. Ms. Bedihi's husband unexpectedly passed away in January of 2015. Ms. Bedihi and her son sought protection as refugees just 5 months later in June of 2015 on the basis that her family had been discriminated against, threatened, and detained by the Iranian authorities because of their religious and political views during their time in Iran. Prior to their arrival in Canada, the applicants traveled to the Netherlands and to the United Kingdom where they stayed with family. However, they did not claim refugee status in either the Netherlands or the UK. The Refugee Protection Division of the Immigration and Refugee Board of Canada found that the applicants lacked credibility on the basis of Ms. Bedihi's delay in making the claim for protection, as well as the inconsistencies in the evidence relating to her departure from Iran, her renewal of her Iranian passport, and the information contained in her Canadian visa. As a result, the claim was rejected. The decision was appealed to the Refugee Appeal Division. However, the appeal was dismissed, with the RID concluding that the applicants were generally lacking in credibility. The applicants felt that the RID failed to understand the circumstances relating to the delayed claim, and that the inferences over their credibility were unreasonable. They further argued that the RID unreasonably applied a Canadian worldwide view to some evidence and focused on minor technical issues and assigning little weight to documentary evidence. They also submit that there was a breach of procedural fairness arising out of the conduct of their representatives, who were said to be incompetent and negligent by the claimants before the RPD and the RID. The issues in this case are whether or not the RID rendered an unreasonable decision, and whether there was a breach of procedural fairness as a result of the alleged incompetence and negligence of the claimant's legal representatives. The court was unable to conclude that the RID's decision was unreasonable or that there had been a breach of procedural fairness. As a result, the application for judicial review was dismissed. Before proceeding to the rationale, it should be noted that according to the Immigration and Refugee Protection Act, a refugee is a person who, by reason of well-founded fear of persecution for reasons of race, religion, nationality, membership in a particular social group, or political opinion, is A. outside of their country of nationality and is unable, or by reason of fear, unwilling to avail themselves to the protection of that country, or B. by not having a country of nationality, is outside the country of their formal habitual residence and is unable, or by reason of fear, unwilling to return to that country. Furthermore, a person in need of protection is a person in Canada whose removal from their country, countries of nationality, or habitual residence would subject them personally to the risk of their life or to a risk of cruel and unusual treatment or punishment. The standard of review applied when reviewing a decision of the RID is reasonableness. This case refers to the Court Judgment of Canada, Citizenship and Immigration versus Hereglica, 2016 FCA 93, where in paragraph 35, the judge stated that a reasonable decision falls within a range of possible acceptable outcomes which are defensible in respect of the facts and law. Reasonableness is concerned with the existence of justification, transparency, and intelligibility within the decision-making process. The standard of review applied in the procedural fairness breach arising out of the allegations of incompetence or negligence in the representation is in reference to the judgment of Gallias v. Canada, Minister of Citizenship and Immigration, 2013 FC 250, where in paragraph 84 it is stated that it is generally recognized that if an applicant wishes to establish a breach of fairness, he or she must A. establish that a former counsel's act or omission constituted incompetence without the benefit and wisdom of hindsight, and B. establish that the outcome would have been different without the incompetence. In respect to the issue of whether or not the RID's decision was unreasonable, the court found that the RID's decision was, in fact, reasonable, as the claimants lacked credibility and subjective fear based on the notions that Ms. Bedihi's failure to take the opportunity to seek protection for a long period of time and in 2 other countries challenges the claim of subjective fear. Ms. Bedihi's ability to renew her Iranian passport without any difficulty was inconsistent with the claim that she was being sought after by Iranian authorities. And finally, her evidence and her evolving testimony was unreliable. In the issue of the breach of procedural fairness, the court found that the alleged incompetence of the formal legal representatives had no effect on the procedural fairness, based on the fact that the applicants could not argue that the RID's decision failed to address an issue that should have been raised on appeal, or that it failed to appreciate a ground of appeal due to the quality of the written representations. I believe that the RID made the correct decision in context to the rules and standards set for them. The RAD found that the claimants lacked subjective fear, which is the necessary component to be considered a person in need of protection. The test used in establishing this fear is bipartite. A claimant must subjectively fear persecution, and this fear must be well-founded in an objective sense. The claimants were unable to establish such a fear in an objective manner. However, while I agree that the RAD's decision was the correct one in context to the standards that were set forth for them, I do not necessarily think that this test or the standards are ethical. I think that the standards should be more closely reviewed in order to establish whether it is appropriate for board members to delve into whether fear actually exists in the mind of refugee claimants, whether the subjective and objective components of fear should be weighted equally, whether the lack of objective reasons for the claimant to fear persecution should negate subjective fear in a refugee claim, and finally, what actually constitutes as a well-formed frame of mind. Thus, I will conclude with the survey question: do you think the test used to establish subjective fear is a valid one? Thank you.